Welcome to week 1 of our spring semester of evidence. This week we will cover the topic of impeachment with pages 485 to 524 from your casebook. The first case that we covered in this week's reading was United States v. Hogan. This is a United States Court of Appeals case from the Fifth Circuit from 1985. As background, we have two brothers that were convicted for importing marijuana and for conspiracy to import and possess with the intent to distribute marijuana. At trial, the government called a witness just for the purpose of impeachment and impeaching that witness with otherwise inadmissible hearsay evidence. The issue here is whether the trial court erred in allowing the prosecution to call that witness just for the purpose of impeachment. This court held that yes, this was an error to allow the government to call a witness just to impeach. They held that a prosecutor cannot call a witness to the stand primarily for the purpose of using impeachment to get in otherwise inadmissible evidence before the jury. Rule 607 abolishes the old common law rule against impeaching one's own witness, meaning that prior to Rule 607, you could not call a witness, and then if they said something that was inconsistent or something that you did not want, you weren't allowed to impeach your own witness, only the other party's witness. However, now you can. However, this rule does not give a party complete freedom to call a witness just for the purpose of impeaching them. The next case we covered is State v. Oswalt. This is a Supreme Court of Washington case from 1963. This case is discussing the issue of impeachment by contradiction. As background, we have a defendant who was charged with robbery and burglary. The crimes were committed in Seattle, and the defendant introduced testimony of a Portland restaurant owner who said that the defendant had been in his restaurant on the night the crimes took place. On cross-examination, the prosecution asked the defendant's witness whether the defendant had been in the restaurant every day for the past several months. The witness said that the defendant had and hadn't missed a single day. The prosecution then produced a rebuttal witness to show that the defendant had been in Seattle for a few days in the past month, but not on the day of the crime, meaning that the defendant's witness had not been accurate in saying that he had been in the restaurant every day for the past several months. At issue was whether or not the trial court should have allowed this prosecution witness to discuss the sole purpose of impeaching the defendant's witness with this extrinsic evidence of whether or not he was in the restaurant every single day. This court held that yes, this prosecution evidence was inadmissible because it constituted an attempt to impeach a witness using extrinsic evidence on a collateral matter. So what is considered a collateral matter? On page 496 in your casebook, this court discussed that. And they held that a collateral matter is, could the fact as to which the error is predicated have been shown in evidence for any purpose independently of the contradiction? Meaning, is that evidence that you're bringing in with this impeachment witness something that you could have brought in for any other purpose? Is it relevant to this case other than to impeach? And if yes, then it's not a collateral matter. If no, then it's not something that's relevant to this case other than for impeachment. In class, we'll discuss the questions on page 497, so please be prepared to discuss as a class. The next case we covered is United States v. Copeland. This is a United States Court of Appeals case from the D.C. Circuit in 1993. As background, the defendant was convicted of unlawful distribution of cocaine. An undercover police officer testified that she had bought cocaine from the defendant using currency with pre-recorded serial numbers. When the defendant was arrested and searched, he was found with that currency in his possession. The defendant claimed that the officer had mistaken him for another man while he was playing craps. The defendant and his own witness testified that this other man had left the game frequently to make transactions and then come back to the craps table, implying that this other man had made the sale to the undercover officer, then lost his money at the craps table, and that was why the defendant then had the pre-marked bills. On cross-examination, the prosecution asked the defendant whether or not he knew the other man was engaged in drug transactions. Had he actually seen the drug change hands? And did he know what drugs looked like? The defendant answered no to all of these questions. The prosecution then introduced evidence that the defendant had tested positive for cocaine recently, meaning that he theoretically did know what drugs looked like. At issue was whether or not the trial court erred in allowing the prosecution to introduce that evidence of the defendant's prior drug tests. This court found that the impeachment evidence was admissible, but reversed because the trial court had failed to give a limiting instruction. So it could have come in, but the jury needed to be limited on how they could use that evidence. We will then cover the casebook hypos on page 502, so please be prepared to discuss. Our next case is United States v. Owens. This is a United States Court of Military Appeals case from 1985. And here we are discussing the issue of prior bad acts. As background, the defendant was on trial for shooting his wife after an argument. The defendant testified that it was an accident because he had handled his rifle improperly. The prosecution then asked the defendant if he'd ever lied under oath, specifically on his warrant officer application. The defendant denied lying, but the prosecution continued to question him, and then the defendant later revealed that he had admitted 2 prior drug and firearm convictions, as well as an arrest for assaulting his second wife, in this current case being the issue of shooting his third wife. So this evidence was brought in by the prosecution's impeachment of the defendant on cross. Under Rule 608B, a trial judge has discretion to allow cross-examination about specific bad acts that are probative of a witness's character for truthfulness or untruthfulness. So the issue in the trial court was whether the prosecution should have been allowed to further question the defendant about lying about the prior convictions after he had initially testified that he had not lied. This court held that the trial judge did not abuse his discretion, except for the fact about the assault on the defendant's second wife. That fact they felt was too prejudicial. However, the court held that this questioning was, though it was an error, it was harmless. And so when looking at the case as a whole, the appellate court concluded that, again, though there was an error in admitting that testimony about the second wife, the error was harmless enough to not warrant a new trial. Our next case is United States v. Sayada. This is United States Court of Appeals for the Third Circuit from 2000. As background, the defendant and his son were charged with defrauding an insurance company. They were accused of intentionally flooding their warehouse by breaking a sprinkler head to collect the insurance money. The defendant put into evidence an excited utterance by one of their employees to prove that it was accidental. The employee in question was a disbarred former judge. The trial court allowed the prosecution to bring in evidence of this ex-judge's misconduct to show his character for untruthfulness. At issue was whether that prosecution's testimony was irreversible error, and this court held that the evidence of the ex-judge's prior misconduct should have been excluded, though again, they found that the error was harmless. Our last case was United States v. Sanders. This is a United States Court of Appeals case for the Fourth Circuit from 1992. This case is discussing the issue of prior convictions. As background, the defendant was charged with assaulting a fellow inmate with a shank and possession of contraband, beating the shake. The defendant claimed self-defense, and at trial, the judge allowed the prosecution to put into evidence testimony that the defendant was previously convicted of assault while in prison, as well as for possession of contraband. At issue was whether the admission of this prior crime testimony an error. The court held that yes, this admission was an error, and the court noted the factors they considered in this balancing test under Rule 609. Whether that prior crime reflected truthfulness, the remoteness of the crime, the importance of getting the defendant's testimony, and the degree of similarity to the prior crime to the charged crime. And that last point is what is the main issue here, where the prior crime was almost identical to the current crime charged. So the defendant would be very prejudiced by this testimony. A jury will see that he has already been convicted of this almost same crime, and so they will use it for more than just impeachment.